What do you think about Kudera? Is he in deep enough yet or not?
I don't know.
Did you see the Globe today?
Nice and wide in the time. What Globe say?
Oh, the headline, him challenging a judge.
Oh, is that what they're feeding it against?
He's got to be done. No.
I just saw it.
Did you see? Going to pick him anymore. He's done.
Did you see? That's why I think your former partner's out of his mind.
He's got.
He's in bed with that him. I don't know why.
You don't get it. If you were on the inside of Borden and Elliott, what would you think? He's spinning this
Yeah,
thing, right?
well, maybe from a career standpoint, it's smart. Yeah.
When's the last time he cared about the law or wrote a brief or anything?
So listen, I don't know if you saw this today. I'm talking about this loss of permanent residence more on the residency side thing. That's all I'm concentrating on because other people were doing, criminality.
Okay. Then let him see if you can draw him in for the 15 minutes he's here. Maybe he's giving some instructions on how to pull the card or something.
Yeah, I'd like to hear that. He won't know. He's not in charge. This guy, Hansra. Hansra. Okay. How are you?
Got the last one out of somebody's hands. There we go. We're going to reconvene because I'm off by usually 1 to 3 hours. They don't pay me for this. Paul might come back, and he might not. So we're going to continue with this program. Stephen Green's to my right, a leading practitioner in the area of immigration law and very interested in issues about how you keep your status and how you lose your status. And I couldn't think of a topic that's more dear and near to a corporation's heart to find out when their employee has lost their status or try to maintain their status. And what measures you can take to preserve that status so that they can keep coming back to Canada and providing those valuable specialized knowledge services to your company. So, Stephen, you want to PowerPoint this?
Sure, I'm going to try to PowerPoint. I don't know how well I'll do.
How do you?
PowerPoint?
I think. Wow.
Good, okay.
Well, this one must have cost you over $200, huh? Just the technology alone was worth it.
What I plan to do today is to go through the process of determining admissibility with respect to a permanent resident at the port of entry, how you keep it, how you lose it, and really, what is it? Under this new IRPA that we received in June last year, they advised us now that you have something called a status document. And Section 31 of the Act indicates that possession of this new permanent resident card means that you're presumed to be a permanent resident. But what really is that card? In my opinion, that card is in addition to your airline ticket. It is really a ticket. It is a ticket to permit you to board an aircraft. That's what it is. If you don't have it, you don't fly after December 31st this year. And Section 148 of the Act tells the transportation companies that if the person doesn't have that card, they don't get on an aircraft. Otherwise, you're responsible for repatriating them back. So if I show up at the border today as a new immigrant and I have my permanent resident card or don't have my permanent resident card, can I come into Canada? The answer is yes. That permanent resident card is a ticket for the airline. So if I drive up to the border through the United States and I don't have my permanent resident card, I'm permitted to come in because I'm a permanent resident, and the officer will admit me. It certainly is the best evidence that you are a permanent resident, but it really is just a ticket. And it's important to understand that through all of our discussions, because having one doesn't necessarily mean you are a permanent resident. So let's talk about people arriving now at the port of entry. What is the duty on that officer? What is that officer supposed to do? That officer is to look at Section 28 of IRPA, and many of you have looked at it, and it tells us that that person has to be present for 780 days with respect to, and this is the important wording, every 5-year period. So the question that should pop into your mind is, can I get a final decision? Because remember, under the old act, it was a final decision when you entered. I submit to you that as it stands today, it's no longer a final decision. And you'll see in the discussions that I talk about how that's going to be a big problem with respect to your corporate clients that are permanent residents, this concept of finality. Is it a final decision? You used to get these wonderful returning resident permits, and all of us argued they were unfair, they were subjective, but at least you had something that was pretty final, and a person was pretty confident about leaving, and they knew that most likely they could be away for that period of time and re-enter Canada as a permanent resident. But let's look at the exceptions now with respect to that period of 780 days. We're told in the Act that you can be away for employment, Canadian spouse, and this humanitarian and compassionate grounds. Let's talk about the spouse. If I am married, if I am in a common law relationship, I can be away with my spouse, provided my spouse is Canadian. But the question that many people ask is, let's say I am the permanent resident and I'm the reason that we are outside of Canada. So it is my intention, me the permanent resident, who has to be abroad, but I'm married to a Canadian. Does that matter? No. The intention of the permanent resident is irrelevant, provided that that permanent resident is with a Canadian common law partner, same-sex partner, or their spouse. They must also be ordinarily residing with that Canadian. If they're not, then they're not allowed to take advantage of that situation. But this Section 28 has created a wonderful thing in one respect. They're kind of called IRPA babies. And what does that mean? If you have been outside of Canada for 5 years, 6 years under the old Act, 10 years under the old Act, and by chance your spouse, common law partner, same-sex partner, becomes a Canadian citizen and joins you outside of Canada, provided you remain outside for the 2 years, you're reborn. You're a baby. You start all over again. So you can reacquire your permanent resident status. So if you were to show up at the border and the immigration officer examines you, as they are supposed to, and they go to Section 28 of the Act, they're looking at, have you been in Canada for that period of time? No, I'm not. How long have you been away? Been away 6 years. But if you happen to have been with a Canadian spouse for that 2 years, or a same-sex partner, or common law partner, then you're reborn. So it's a very important thing that you can advise your clients with respect to, should I enter now? Maybe I should wait. If I enter now, the officer is generally under an obligation, if I don't meet these residency requirements, to take it away unless there are humanitarian and compassionate reasons. Outside for business. Some of you may recall that you used to assist many of your clients in getting a returning resident permit. A lot of them became the self-employed consultant, and they had their returning resident permit. Well, I think under IRPA, the Parliament of Canada has directed their mind to make sure that any time a person is away for business, it was not set up primarily, and that's the wording in the Act, for the purposes of being away and meeting these requirements under the Act. So the reason for their absence must be related to business, and there is this concept of, is there a possibility of profit in the business? And what do you show the port of entry officer? The manual material seems to indicate that if you are away business, you should show them articles of incorporation. You should have a letter, if you're an employee-employer relationship, from your employer stating that you've been away on behalf of the Canadian company. How long are you going to be away? Obviously, if it's a large public company, you don't have to worry about the concept of generating profits, but that is a very, very big issue that you have to look at with respect to being away for the business purposes. Children. Children are allowed to be away with you, but unlike the other sections of the Act, here they specifically put an age requirement on who can be away with their parents as dependent children, and they define it as a child, not as a dependent child, as in other sections of the Act. So anyone 22, less than 22, can be away with their parents if they're away with a Canadian spouse or if they're away for business. But if they're over 22, they're on their own. And they have to be able to justify, just like anyone else who's being admitted as a permanent resident at the border, that they meet the requirements. H&C, tough, because it's every 5-year period. If you enter at the border, you don't meet the requirements of being in for 2, you can make your humanitarian and compassionate request to enter despite the fact you don't meet the residency requirements. But again, it's this every 5 years. Is that decision final when an officer makes it? The way it stands now is, I don't think so. So you may satisfy a port of entry officer, H&C, you get in, but if you leave again, you go through the same process again. So you may want to advise your client that if you make it, stay the 2 years or find another exemption that you may qualify under, perhaps Canadian employment, that type of thing. Intention is not an issue to the port of entry officer with respect to H&C as it was under the old system. Remember the old Adams case where you had to meet a 2-pronged test that the person was outside of Canada for more than the 6 months, and what was their intention? You can't come up to a port of entry officer and say, I didn't intend to be outside of Canada for whatever reason. That's not the issue here. Intention is not the issue. And it was a determining factor under the old system. What do they look at? Pretty similar to a lot of our agency applications we do to show, settlement. They want to see what ties do you have inside of Canada, and they actually give you a questionnaire that you can fill out for deferred examination. You come back, the officer will look at it. Was it beyond the control of the particular person why they were away for such a long period of time? Did they come back as quickly as they could, or did they wait? Medical reasons. They look at, obviously, the days in, the days out. That type of calculation is also done, and hopefully you get a positive determination and you can meet the humanitarian and compassionate reasons. But again, it's not final, and I think you have to warn your client. So what happens? I'm determined to be inadmissible as a permanent resident. What is the actual process that this particular officer goes through? Do you have a right to counsel? The department is of the opinion you don't. I'm not so sure that would satisfy a court. I think that we're dealing with permanent residents now. I think that you're losing a pretty serious right. So I would believe that you do have a right to counsel. The department doesn't think you do, but we'll have to see what the courts have to say with that. Unlike other provisions of inadmissibility, there's no inquiry here. The officer looks, counts, no H&C, inadmissible. You do not go before an adjudicator. It goes directly to a removal order. IRPA says the type of removal order that is issued is a departure order. You do, however, have 30 days to appeal that, and until that decision is made, it is not a final decision. You are eligible, if you choose, for that permanent resident card as well while this process is going on. It's only valid for 1 year at a time, unlike the normal process where it's valid for 5 years. So there is no opportunity to go before an adjudicator. You go to the board, and the board will decide how the process will work. I'm outside of Canada. It's past December 31st, 2003. I'm also outside of Canada. I'm a new immigrant to Canada, but I'm from a country that requires a visa to enter Canada. What do I do, and what does the port of entry officer look at? I have to go to an embassy or consulate outside of Canada. I basically go through the same process that a port of entry officer would do to me at a consulate abroad. If I can satisfy the consulate that there are humanitarian reasons, or that I happen to have been in Canada for 1 day within the past year, they will give me a facilitation document which will let me board the aircraft and then come to Canada and deal with the officer. If my case is refused abroad, I have the right to appeal. But if I happen to have been in Canada within 1 year, then the embassy abroad will give me a facilitation document, provided I appeal that decision to the immigration board, and I can come in. The officer will examine me at the border, will see my facilitation document, and will let me in. And again, I must wait until a final determination by the board as to whether or not I'm allowed to keep my permanent residence or not. But it's a very interesting concept now under this act. Some people will say it's a good thing, some people will say it's a bad thing. You're stuck for life with your permanent residence until a determination is made. There is now almost no process to voluntarily say, I want to abandon Canada as my place of permanent residence status. Because they've instituted these appeal rights in here, it's very difficult. So for example, I am a permanent resident of Canada. I've been living in Italy for 20 years. I now want to come back to Canada to visit my family. I hop on an airplane. I come here. The officer says, what is the purpose of your entry? I'm coming here to visit my relatives. What do you mean visit? You're a permanent resident of Canada. I don't want it anymore. Well, I'm sorry, you're stuck with it. You can't just abandon it. They will do a report that you've been outside of Canada. They will then say, you have 30 days to appeal it. So until that 30-day period is over, you're stuck as a permanent resident. And I'll even give you another extreme example where we had a situation where it was an American citizen who was a permanent resident of Canada in the States, years and years and years, had decided they were going to come back up to Canada under NAFTA. They go and apply. The officer says, sorry, I can't give you a work permit. What do you mean? You are a permanent resident of Canada. No, I'm not. I've been out forever. Well, no, I have to start working today. Go to the consulate, they'll deal with it. They go to the consulate tells them the same thing. Sorry, you're a permanent resident of Canada. We have to make a determination. They make a determination that you've lost it because you've been out so long, but they can't give you your work permit because they have to wait for the 60-day appeal period to run out. So be careful with respect to old permanent residents because they still have it. And I guess the most extreme example that I've come across is someone that was a permanent resident for many, many years, American citizen, came up to Canada under the old act, had a work permit for 2 years, working in Canada. They go to renew their work permit for a 3rd year. After IRPA comes in, the immigration officer goes, sorry, you're an immigrant. What do you mean you're an immigrant? Section 28 of the Act says that if you've resided in Canada for 2 years, you get your status back. You're reborn, and now the person is now applying for citizenship because they acquired it. They were born again because the Act doesn't say you reside in Canada as a permanent resident. It just says that you're physically residing in Canada. A mistake. I mean, that's, an extreme example. So you have to, I guess, ask the question, if you're dealing with someone that was a permanent resident and they're going to be entering Canada, how long, what's going on? You understand that we can't get you a work permit right away because you've got to wait for this appeal period. You have to go through this determination process. So be aware of that. Returning resident permits, port of entry. They basically have extended the residency rule for you if you received one in the past 2 years. So it's still a valid document for you if you received it before June 28th of last year, and it provides you from the exemption of being physically present in Canada. So for example, we have a client of ours that has a returning resident permit. It's expiring, let's say, today, and they've always been on one. Now their 5-year period starts and they can be away for another 3 years. So it exists for now. Use it. I don't know how many people are entitled to that. And I guess my final comment would be that it is not a final determination, and you have to advise your clients very, very carefully with respect to leaving Canada for a long time.
What do you think about that? Before you run. One of Stephen's clients comes through and an officer has looked at the facts and made a determination that he or she meets the 2-year period after there's humanitarian and compassionate reason, for whatever reason, does not write a report but says welcome back, gets back on the subway. Is it your view, or do you understand the view of the department that if he leaves Canada and goes to Buffalo shopping and comes back again, that whole examination process occurs again on exactly the same set of facts that could go the other way 2 weeks later?
I'm not sure I understand your question.
To what extent is the decision binding that's made by an officer who has let you into Canada, confirming your permanent resident status, when you leave Canada and re-enter again and have a different determination made by another officer?
I would think that if the legislation provides for it, then the client should be willing to put up with that crapshoot.
Wait a moment. And you're not a lawyer, right?
I'm not even a lawyer, no.
Sounds like a lawyer's answer. What you're saying is you're vulnerable each time you enter the country to the exact same evaluation by a different officer, and just keep your fingers crossed that nobody sees it differently.
Well, the same thing happens with your work permits. The same thing happens with somebody who's been admitted as a visitor, a long-term visitor. They're subject to an examination each time they come back.
But
In point of
practically
fact,
speaking, there's no, you don't have to reiterate the reasons why you got the first work permit when you come in again with it.
And these are permanent residents, not visitors.
and the likelihood of someone coming to a different conclusion and not respecting the conclusion the first officer came to with regards to a permanent resident is not too likely. Normally, if the one officer has gone through the whole 9 yards, come to a conclusion.
So you document that decision's in the computer. If the second officer calls it up, he sees that there's been some thought process applied on another occasion, and he can see that this wasn't just a decision that was made without any computer entries.
Most likely that would result in a computer entry on FOSS. If the complete rationale was not available to them, they would probably defer the examination in order to get a complete rationale from the officer who made the original decision.
Another issue with respect to this 5-year period is the following. I don't think you can, well, you can't advise your client of this scenario. Becomes a permanent resident, 5-year period. They go away for, they're in Canada for 3, then they leave for 2, they apply for their card, they're eligible, and then they go away again for 2 more years. So now, in essence, they'll be out for 4. So they're not eligible. So you can't say to them, once you get that card, you're safe. You have to look at the whole situation, and you don't want to leave your client can't be in a position to leave their absences to the end of the process because it's a continuum. It's not a final decision every 5 years.
Stephen,
You're constantly getting into the mathematics of it.
Stephen, do you want to comment?
That's the way the legislation was drafted.
And you know, we can't help students anymore either.
Do you want to comment on how this dovetails with the new proposed Citizenship Act and regulations? Are you comfortable doing that now in terms of the time periods?
Well, you know, it'll be interesting to see how they're going to do it because, you know, when you fill out this new permanent resident application, you have to document your absences. You have to find a lawyer willing, I don't know how many are, to guarantee that you know exactly what your client's been doing for 5 years. Good luck. And then how is that information going to be protected and not passed on to the other part of the department, citizenship? So you better advise your client to be very accurate and very careful when they fill out their permanent resident cards, because I think the two are going to mesh over. They are, right now, the citizenship bill does not adopt this exception rule here that you can be away for business. We're trying to get that in, but it doesn't. They're looking at 3 years out of 6 of physical presence, which is pretty confusing for people because they're talking, you know, now immigration's, you know, 2 years out of 5 you got to be in, and citizenship now is 3 out of 6, and how does it work? So it's pretty confusing. I don't know how far it'll go. But.
Speaking of being reborn, if you're away too long, but not checked carefully at the airport, which is very likely to happen in many cases given the speed that people come through and so on. So technically you could have been found not resident, but you weren't caught. You're saying, I think I heard you say that if you stay put for 2 years, you're reborn.
Yes. Yes, and I guess another extreme example could be you don't meet the requirements, you find a Canadian employer. You've been away 20 years. You find a Canadian employer, you say, look, I've got all this expertise in Kuwait, I know all this great stuff, I can bring you lots and lots of business, employ me. Make sure you stay away for another 2 years, employed by a Canadian company that's in a position that they could earn money, then you're reborn again. So there's a lot of birthing in this act.
What if you're out of Canada for 6 months or longer under the old Act, and the deeming provision kicks in saying you're automatically deemed to become abandon your permanent residence, and then you come in under the new Act post-September, June 28th, are you automatically gone?
The question that he's asking, and no one's been able to give anyone a definitive answer on it, and it's been asked at many conferences, is that let's say you've been deemed under the old Act because you've been away so long to have lost your permanent resident status, and then you come up to the border now, and can you be reborn? And some people say, well, how can you be reborn because you lost it way back when? You can't be born because you've lost it now. Other people say, well, you never really lost it because there wasn't a final determination. So there isn't it's a gray answer with respect to that.
I think you're reborn. Under the old legislation, the presumption is rebuttable, so that although your absence means you abandoned, then the onus shifts to the immigrant to demonstrate that their facts in their particular case to show that they intended to maintain their ties to Canada. So it's a rebuttable presumption, not an automatic presumption. And therefore, it's never really lost. And therefore, I don't even think you're reborn. I just don't think you lost it.
The onus is on the applicant to rebut that presumption.
And there's no one-
New act,
there's no one to
mechanism
rebut it.
for doing so, because it's a new act. So how can, there's no way to rebut it.
Well, that whole process has not been completed because the applicant wasn't allowed to continue through the process because the legislation changed. I don't think it's gone. I don't think only half of it applies. The rebuttable presumption arises, I'm sorry, now you can't rebut it because there's no legislation, so it's gone. I don't think that's it.
So practically, what happens in that case, if that permanent resident comes to the border, they issue a report, he makes his appeal to the appeal division?
Yeah, he or she goes right to the appeal board if they want to appeal, or if they just want to remain a visitor, they can't become a visitor for 30 days.
And there hasn't been any cases like this yet?
No.
What's even more interesting, Stephen, is would you counsel your client to get on the plane? You don't have to answer this if you don't want to. Would you counsel your client to get on the plane if your client had been absent, in your mind you knew your client was absent from Canada for 4 years?
Well, you have to put a time factor in because he couldn't get on the plane. He could get on the plane up until December 31st this year, but assuming that's not an issue, I think, I would say to him, look, you'd have to satisfy an immigration officer at the port of entry. There were humanitarian and compassionate grounds. If you can't do that, go get married to a Canadian citizen, live with him or her for 2 years. If you can't do that, find a Canadian employer, be away for 2 more years, and then come back. That's about the best you could do. They tried to make it so, transparent that that's the way it works.
Do you provide any of those services? No. No.
The question is, what happens if you don't know about this card and you're outside of Canada? What'll happen is the airline, and even now some of the airlines are enforcing it incorrectly. They tell you, sorry, we won't let you board. Go to the embassy. You have to get that facilitation document, and that will let you board the aircraft. Or if you have a U.S. visa and you can get into the United States, you can drive up to our border and enter. And that was always one of the bar's big submissions, was that it's unfair because visa-exempt countries have more rights than countries that require visas to enter Canada.
You mentioned here that if they've been months in Canada, within the last 365 days.
Yep. Then they can't get a facilitation document, and only thing they can do is satisfy the immigration officer at the embassy abroad that they meet Section 28. If they don't meet it physically, they're not working for a Canadian company, then they have to show H&C if any exist. And if they can't satisfy the officer, then they have a right to appeal it, and they have 60 days to appeal that, and it goes to the board. The board does it on paper, or you can make a motion to appear in person. Once the report is made, the resident is allowed to enter Canada, and they're kind of in a limbo for 30 days. Because if I understand the systems, the port of entry officer enters everything into FOSS, where the person is, all about their information, and they wait that 30 days to see if they're going to appeal. If they appeal, then they go to the board. They're a permanent resident. There's no final determination. They can apply for the permanent resident card. It'll be valid for a year. That's what they get. No, there hasn't been a final determination. They're still a permanent resident.
Stephen, just for clarification, so I work for IBM Canada. I hope nobody in the room is IBM Canada. And I go to IBM New York, and I go on the payroll of IBM New York. So I'm not on the IBM Canada payroll anymore. Am I protected under the exemption? Am I still in Canada while I'm with IBM New York?
I don't think so.
Well, okay.
I think it's one of those gray areas. It's tough. Again, if I was a port of entry officer, I'd probably want to see the type of visa you received. Was it an intercompany transfer visa? Was it an H visa? Those types of issues I'd look at.
I'd like to know how courts are actually treating this. Like, what if somebody shows up at the port of entry and they've been out of the country for a year and a half? What generally are they doing these days?
You're asking the wrong person for that. You should have asked Carmen Cece to be here, because he's been looking after the permanent resident file.
The year and a half is fine. Just can't be more than 3. So I can come up to the border and say I've been away for 2 years, 363 days, no problem.
So then in that case, the fact that you were a permanent resident under the old rules, you're then stating.
You're
that
born
you were
again.
redeemed. You were born again, and that's that.
Yep.
When you apply for a permanent resident card, do you have to be, does the applicant have to be in the country?
That's one of the big issues. Do you have to be in the country to apply for the permanent resident card? The department is of the opinion absolutely you do. The regulations just indicate that you have to apply at a center in Canada. So there's been no determination on it. The bar says no, you don't. The department says yes, you do, and they seem to be winning because they're sending them all back.
I had a client who's landed in August, he landed at Niagara, and he was told he had to apply in Canada, but then he could go back to the States to continue his job, and it would be okay to get his PR card sent to his wife.
I mean, you can, I guess the only issue, if you enter Canada landing for the first time and you say to the officer, hi, I'm going back on my H-1 to work in the United States, the officer could say to you, you're not an intending immigrant, and therefore I'm not going to land you. So I guess that's the only issue. But once you're landed, you could go back. So it's a tough, with respect to advising your client, they have to be an intending immigrant if they're applying for immigration. So, and I know that they have a big problem with this issue in Vancouver with the IT industry there, because so many people were applying, they were under H's, they all applied, they came up to the border, and 2 seconds later they were, going through the other line to get back to the States.
Well, the good news is they're still awake.
Would it be fair to say if you can't give up your permanent residence that after December 31st, you have to actually go get refused the facilitation document, not appeal, and then reapply for permanent residence if you want to do that?
It would be correct to say as of June 28th, 2002, you can't give up your permanent resident status.
Right, so after December 31st, if you haven't been here in the past year, and you get refused the facilitation document.
Yep.
You can't satisfy 28.
Yep.
Here you have to wait, you have to.
60 days.
You have to apply for this facilitation, get refused.
Right.
not appeal.
Yep.
You can apply for permanent residence.
Yes, we're doing that exact situation now in Buffalo. And they've got a whole form your client fills out, and we say we don't want to appeal, we want to waive our rights. And there is talk about it in the manual that you can waive your rights, but they're not accepting it, so they make you wait the full 60 days. And it was a terrible situation with the American that was a permanent resident because he was needed urgently in Canada, and we couldn't give him any document because he couldn't get his work permit. And he said, it was terrible.
There's a strategy that comes out of all this. That if you act for corporations, you'd be wise to send a letter off to the HR department indicating that they should be reviewing their records to see who are only permanent residents in Canada, and remind those employees to go get the card before December 31st of this year. Otherwise, those people are not going out on assignments, they're not going to conferences, they're not coming back. They're going out, but they're not coming back. And someone may ask why the lawyer didn't say anything. Thank you. Oh.
A question, I got this asked actually this morning by an HR person where she had some suspicions as to the authenticity of a document and whether or not, I'm not going to go into the circumstances as to why she had these suspicions. And she came to me saying, well, who do I go to? Do I go to the police? Do I go to HRDC? Do I go to CIC? Who should I call? I don't want to blow this out of proportion because it could be authentic. It's just there was something there that kind of raised a query. And so I'm wondering if anybody on the panel has a suggestion as to where she should go.
Depends on the document.
Both a social insurance card and a work permit. She has some suspicion as to circumstances.
Well, it would be CIC for the work permit. It would be HRDC for the social insurance number card.
Yeah.
And I would tell your client to watch out for the deeming provision in here to make sure that she documents it in that particular employee's.
She left a message with HRDC a month ago and no one's responded, so she phoned me to see if I knew anybody. So if anybody has a suggestion, better I'll listen to it. But I will tell her to document it.
Anybody?
This may not be common, but I'm wondering if any of the people on the panel have any experience with IT professionals or anybody who's had H-1B, but for whatever reason
Well, currently, your status in the United States is not an issue until this Regulation 11 comes, which may have an impact on where you can make your application. So you're out of status in the United States. Now, having said that,
As an immigrant, though, not on a worker side, though.
well, on a worker side, well, now let's just think about that one moment, since it's changing around a little bit in the United States. Some consulates in the United States were more sensitive to your status than others. And so you really went to the consulate that didn't care what your status was, so long as you could meet the requirements of your work permit application. And so my sense of it is that your status in the United States will not govern the approval of the work permit application.
Which consulates was it very sensitive?
Well, name a couple and then I'll tell you. My sense is that, well, there's a twist because some of the people who were sensitive have moved to the consulates that weren't sensitive. So I'm trying to give you proper advice now, but I think you probably won't have a problem in Buffalo. Or I might be wrong because Yusra's shaking her head heavily.
You won't have a problem generally in New York anymore. You used to have a problem in New York. But if somebody was lawfully admitted on an age, and let's say they were in the United States on an age for a year, then even under the new provisions, they're still fine because they were lawfully admitted to the United States for hopefully 1 year. So the fact that it's lapsed 2 or 3 years later shouldn't catch them.
Okay, excellent, thank you.
Tom Clasper recently told me that his view on R11 in these cases is that if they were admitted initially into the United States for at least a year in legal status, that they will and they should actually consider the applications in the States rather than transfer them because they will have more access to the person's history for program integrity reasons.
Charles Play has indicated that Tom Clasper, the deputy program manager in Buffalo, is saying that he will fasten on the legality of the entry to the United States and not the current status when R11, Regulation 11, comes into force, which determines where you can make your application. And R11 has a requirement in it that you have 1 year of legal residence. I hope I haven't said that wrong. 1 year of legal residence in the country in which you're making your application.
And the reason the department's policy behind it is they want to prevent smuggling. So they say that if you came in legally, we're not after those people, but if you were smuggled into the country, we don't want to facilitate those people. So that's the rationale behind it.
Medical reasons for agency be more than being too sick to travel back to Canada should be, for example, very comfortable with your overseas position and you want to leave for the first year?
You know, the question is, you know, per someone's ill overseas and they want to be taken care of by their own family physician. Again, you know, it varies from officer to officer. Under the old system, we used to say the same thing, and some officers would say, sure, we'll give you a returning resident permit. Other officers would say our medicine in Canada is just as good. Citizenship applications, the same thing. A lot of people were away from Canada. They didn't meet the residency requirement. They said I was away because I wanted to care about my family physician. Again, it varied from judge to judge. Some would accept it, some wouldn't.
I guess I'm wondering if that's a stronger position than I was in prison. At least one has a voluntary aspect to it, huh?
Hired employees in the past who have been on the work travel 12-month approval.
Yep.
And in 3 cases, each has been dealt with very differently by HRBC and the labor market assessment. Once we were told that they were ineligible to be renewed altogether, that told us they had to return to us Canada. The second time they were processed as a new, and the third time they were told to process as a renewal. So I just wondered what officially is the method that should be approached.
I didn't hear the first part. I'm sorry.
The question is, I guess it applies to the EO8s that we're all familiar with. It also applies to the SWAP, the student youth programs where people come in and you want to get a renewal. Again, it varies from officer to officer, and it also depends on the manner in which they found this particular foreign worker. If they went through the normal recruitment stuff, then you shouldn't have a problem. But if it's a recent grad who they didn't go through any recruitment, they just happened to pick that person, you will have issues and not be eligible to get it, generally.
An EO8, the old EO8, has no right to a redetermination for a work permit based on the merits of that EO8 or a SWAP, a student work abroad program. So what we found is that they're under the normal system of neutral or positive, and then it comes back to that discussion this morning, entry level, and their pay. We had one like that, and they were just 1 year on a SWAT, 1 year on a EO8, and all of a sudden they said, look, they don't make enough money, their position's not high enough. There are Canadian students who are graduating who could do that job. Done.
Stephen, were you saying if you have someone who's a permanent resident, maybe 20 years ago and doesn't want to kind of sneak into Canada and try to reassert, after 2 years, that if you file the new application for permanent resident status with the old record of landing and you say, he's given it up and he waives appeal rights and all that, you still have to go through the determination for facilitation documents?
I would say yes, it's a problem. And I don't know what the department's doing about it because you're still an immigrant. So I don't know. I don't know the answer to that question. I know the Buffalo is taking the position that they have to do a determination first. So.
I've got a similar situation where you're a permanent resident 20 years ago, left 20 years ago, came in September 2002, had a report written up, referred to inquiry. I don't know why, but they said we've written up a report, we will be referring it to a inquiry. No inquiry is being invoked because I guess they realized there's no inquiry for this. And it's still sitting there with no final determination. So I'm wondering if the officer finally makes the final determination, says you failed to meet it, then we're going to the IED. Is the IED going to make a decision as of that date? Because that date's going to be, by now, going to be 2 years later than the time the initial report was made up. So he's had 2 years of residence here. According to one section, I can't remember what it says, any residence accumulated after the initial
Doesn't count.
But it's a trial de novo, meaning we make the decision as of today. And I don't really want to call this officer in jargon
wouldn't.
and rock the boat and get a decision.
I wouldn't, because I think you may have a great argument in law that they've written the wrong report, and therefore the exception saying that while you're in Canada under a Section 44 report, the time doesn't count. But this person hasn't had a proper report written, so you might be okay in law. So I'd maybe stay quiet.
But is the report proper, just not disposed of properly?
Well, you can't, I don't know, the process in law, they've done it incorrectly. There's no authority for them to refer to adjudication, so it's done incorrectly. Is it a 20 report he wrote, or was it a 44?
44.
I don't know.
Is there any way to know if that 44 report has been finalized? Like they said, okay, actually we didn't refer it to inquiry, we've just been sitting on it.
Yeah, they may have done a deferred examination, they haven't, done it yet.
Will we get a final decision on that, or will we just throw it away?
Don't know.
I would think
I think that report's gone.
somebody is I can't even imagine how they would have sent it to to an adjudicator. And even if they did send it to the adjudicator, why it didn't come flying right back in the next mail run.
And your client's missed the whole thing. I mean, he's missed his right to file an appeal because it's only 30 days from that decision.
No decision was ever made. Well,
Yeah, I don't know.
Anybody got an easy one? Anyone not under report? Okay. Well, I think that ends Canada. Unless, Paul, you want to add, you were
There's
gracious.
only one thing on this whole issue, and to be very honest with you, I don't deal with this issue hardly at all. So I only have a superficial knowledge of it. but I believe the manual chapter, and it might be ENF 4, was updated either just before Christmas or just after Christmas to reflect some changes in policy regarding the abandonment issue. And I know that whole issue is being worked on by the department. And it is a rather thorny one. From the perspective of the port of entry officer, the last thing they want to deal with is some elderly parent who at one time lived here and simply doesn't want to live here anymore, but they want to visit their grandkids. And the last thing they want to do is put somebody like this through the report and determination system. So it is an issue that's being dealt with, and it is being taken quite seriously. When it will be finally determined, I'm uncertain. It's my understanding, though, it will take a change to the Act, not just the regulations, but the Act to get something finalized on this.
Can Paul just comment on the scientific technologists that he didn't get to from the last session?
Oh yeah, that's why I hung around. For those of you who are not aware, when the Foreign Worker Manual came out last July, Foreign Worker 1, the new one, which I was under the impression was going to be revised and reissued around the new year, but we're still kind of waiting. The NAFTA component of that Foreign Worker Manual contains new guidelines for scientific technicians and technologists, and these guidelines were agreed to at the NAFTA Working Group meeting in 2001, November, October. And so the guidelines are articulated in that NAFTA component. So if you are dealing with a scientific technician, technologist entry, I suggest you do look closely at those new guidelines. Over the past 6 months, I've sent at least 2 emails to the Port of Entry staff in Ontario, so they are aware of the new guidelines. And particularly, one of the big changes with the technicians, technologists, is that generally what you're looking at is a person would have some sort of a diploma after successful completion of a 2-year course. Some people were looking at that very, very stringently, and the key word is generally should have a diploma, so that would indicate that not in all cases a person would have some formal educational training, and that has been brought to the attention of the Port of Entry officers, so it should not be an issue. In cases where a person does not have a diploma, be prudent to outline clearly and concisely how the person meets the qualifications through their experience. And that was really all I wanted to say on the STT issue.
That's it. This afternoon, we're going to touch on American immigration, which is a lot more lively than Canadian. And they're not half as funny as Paul is. 2 officers are coming over from the U.S. consulate, and they will be discussing the chief of the non-immigrant visa section, and a visa officer will be coming over for Joel Guberman's panel on consular processing. Heather is going to go through the new organization of the U.S. Immigration Department in the United States, which is going to be rather dramatic. And I think Asher Frankel is going to talk about TN provisions and how you get into the United States using professional categories. So I think you'll find it all right on point in terms of moving people around across the borders. We're scheduled to resume at 1:30, but let's make it around 1:45, and or as close to it as you can get. Thank you. In the front of your binders. If you're not going to stay the whole day, you should try to fill them out as soon as you can. That's how we figure out how to do the next program. Thank you.